First, I think it's important to remember that as lawyers, we aren't medical specialists. We don't have expertise in mental health, and we shouldn't expect ourselves to appreciate or have a thorough or detailed understanding of different diagnoses, the different medications or different symptoms that individuals might experience if they have a mental illness. And certainly we shouldn't consider ourselves not fully equipped or trained to assist an individual just because we don't have a thorough understanding of the different types of mental illness. For example, a general understanding is more than enough, is generally appropriate to assist an individual, and a general understanding of how a mental illness can impact on an individual, the fact that different individuals can experience mental illness in different ways, and that mental illness and medication can fluctuate quite significantly over time as well. Second, I think it's also important, very important, to remember to treat the individual not as as a mentally ill person, but rather as any other individual who may be experiencing symptoms of a mental illness that are beyond their control. It's important not to consider or to view the individual or anything that they're saying through the lens of mental illness. It's also important, of course, to be conscious of capacity issues. So the lawyer should be remembering that a mental illness might impact on an individual's capacity to make certain decisions or to give instructions about certain matters. So it's important for the lawyer to remember their fundamental ethical duties and, of course, start from the assumption that the individual does have capacity. The lawyer should, of course, also remember that they can and should take steps to maximise the individual's capacity when assisting the individual. There are a lot of factors that can be taken into account when considering capacity issues, and these are outlined in more detail, for example, in the Queensland Handbook for Practitioners on Legal Capacity. Of course, the Queensland Law Society's Ethics Centre can also provide guidance on these matters.
In setting aside time to interview the client, it's important that that is real time. Also, that realising it may take more than one interview. I've certainly heard other lawyers who work regularly say, look, you need to set aside about 2.5 times the amount of time you would ordinarily expect. You might, if you feel that you're going around in circles, it's better to stop the interview even early and reschedule for another day rather than be frustrated with your client, because that is so counterproductive and will build a barrier between you and your client that shouldn't exist. You're asking very neutral, open-ended questions. Today you seem very anxious about talking about that, or I've noticed that you're not very clear, in your answers. I'm just wondering if there's a better time that we can meet to talk. But sometimes people can get quite distressed quite readily, and as lawyers we may not have the skills to inquire terribly much about those issues. So you're better off, a better line of inquiry is, someone else who I can call, it seems you're getting distressed at the moment, to assist you or to assist us in what we have to achieve today. Someone who the person trusts, that could be a family member or a friend, or it could be a professional. Medications and side effects are very individual. So what affects one person, you might have had a previous client who had a bad reaction to a particular medication, may not apply to the next person that you see. So you can't carry over learnings from one client to the other. So it's important to just ask straightforward and neither have a negative or an overly positive view of medications, just neutral fact-finding questions. What are they on? What medications? What's the name? How do they take that medication? Because that can vary considerably and give you a lot of information. For example, are they on an injection or a depot or wafer or just tablet form of medication? It can give you a lot of information. What are the doses, morning and night? How does that affect you? How do you find taking that medication? Another useful question is, how long have you been on this medication? Because they might have been fairly settled and been on it a long time. they might have just started it a month ago. Asking, you know, when's the best time of day to meet you? You want to get instructions when clients feeling most comfortable and confident, and get the most information from them. And also you can find out if the question of capacity comes up along the track, that you've interviewed them at their best time. So factors that can impact on capacity, for example, some people take very heavy nighttime doses of medication, so the mornings are really difficult for them to wake up and they're a bit groggy in the mornings. Sometimes people might be on a course of ECT, so it's best to leave a couple of days after a dose of ECT. Some people may or may not be comfortable to talk around the time that they have a depot. It might cause them a lot of anxiety, or they might have some side effects around that. So just asking when's the best time, and also date if they have sort of fortnightly treatment events. Sometimes either the person themselves or the referring person, such as Harry or the health professional, can identify the legal issue. However, the research shows that that's quite often not the case, that that something's not working well for the person, and maybe a lawyer can help, can sometimes be the best way the problem's articulated. So that therefore we can utilise great tools such as the legal health check when the referral's unclear, to help identify what might be the issues for the client. So the legal health check will cover a range of common legal problems, and we'll go through, and it's also written in very much plain English, because if it's written in legalese or the questions are in legalese, you know, it'll sail over everyone's heads and we won't be terribly helpful or meaningful. So legal health check is quite a good tool when there's a non-specified referral. If there's a specific referral and people said, look, I really want help with my pension, that should be reinstated, you don't want to irritate people by asking a whole lot of other questions first. So at that point the legal health check might be used when the first legal issue is addressed, to check that there's no other outstanding ones.
One of the things I do when I'm talking with somebody who I think is anxious or is having difficulty retaining the information is to give them small pieces of information at a time and then discuss it with them so that I can have them repeat back to me in their own words how they understood what I said. And then as we build on the conversation and get further down, you're making the topic sort of broader and broader, and then at the end you can ask them to summarise what you've said over the session, so that way you have a better idea that they've actually understood what you've said. If they have a support person or carer that's with them and that person is really anxious, it's time well spent to, the term we'd use is de-escalate, or to calm that person, and to spend some time talking about what they're anxious about so that they're calm and settled, because that's going to help the client be calm and settled. Anxiety is really contagious. If the lawyer's anxious about it, if somebody else in the room is anxious about it, it's going to be really difficult to have a calm and smooth interaction with everybody.
The family and the carers are often there on the front line, so involving them is so important, I think, to getting a positive outcome here. Having said that, you really do need to get the permission of the patient in order to do that. They need to have full consent and for everyone to be participating in this conversation, because it's often very personal information that is being shared that would ordinarily and should be kept confidential. So they need to be comfortable with that sharing of information, but also they need to have an opportunity to be able to talk to me, to talk to Karen and the people in the clinic on their own as well, because sometimes even well-meaning families and carers can be part of the issue, part of the underlying issue behind whatever that social or medical legal problem is.
It's probably more usual for lawyers to meet one-on-one with the client, and so ordinary practices is, you know, getting client authority, you know, who is it okay for us to contact and who is it who you don't want us to have contact with, and just in relation to fluctuating capacity issues and level of comfort and confidence that clients will have over time, it's important just to check in. Is it still okay for the support worker to come in, or shall we just do this interview? It's important, as Harry talked about, the sixth sense. To listen to yourself and your own reaction. Something's a bit different about this presentation today, and so you might ask a few different questions before you get going, or if you're not sure, if it's not clear the information that's coming from you, is it still okay to give your mum a call or your case manager a call about this, so I get the full picture, and because I just need to clarify. So whilst they might have given permission beforehand, you just want to develop that working alliance and not be working against your client. So it's very, very important.